Bankruptcy.
Right.
Challenging issue when we're working on a transaction and there's either a pending or some type of intervening bankruptcy. Now, I understand from a personal basis there's two types. There's a Chapter 7, which ends up potentially a full liquidation of assets, and a Chapter 13 where a homeowner might be able to reaffirm an existing mortgage. Let's talk about Chapter 7, the one where they're going through the full kind of liquidation and absolution, if you will, of those obligations.
So when someone's in bankruptcy, the question for everyone that's trying to transfer the property is, who has the authority to transfer this property?
Yep.
And it's going to be one of two people.
Well, what happens the minute that somebody files bankruptcy?
Well, the minute you file bankruptcy, there can't be any more foreclosures. It stops the foreclosure process, if it's in process, dead. If they've already gone to sheriff's sale, which is part of the foreclosure process, the right of redemption continues.
Right.
But if they haven't gone to sheriff's sale, then the whole foreclosure process is stopped in its tracks.
Yep.
Once they file bankruptcy, now the question becomes, can that homeowner still sign, for example, the deed transferring the property?
Right.
And that's going to come down to what the bankruptcy trustee who's in charge of this bankruptcy case is going to do with the property.
And they're appointed right away. The bankruptcy trustee is appointed
by the court.
By the court, yep.
And it's up to the bankruptcy trustee to determine whether or not there's any equity in the property, because you've got the bank that might have the mortgage on the property, but there might be a little bit of cushion in there where there's more money available.
Right.
If there is, the bankruptcy trustee wants to take that money and distribute it to the other creditors of the person filing bankruptcy. If that's the case, they're going to control the sale, which means the bankruptcy court has to approve the purchase agreement, the sale proceeds, everything, and all the proceeds get paid to the bankruptcy court.
And at that point, the real estate professionals are talking to the trustee directly.
That's exactly right.
Okay.
On the other hand, if, for example, the debt exceeds the value of the house, or, for example, the trustee just doesn't believe there's enough equity to bother with it, per se, well, then they could abandon the property. The trustee, it's a legal procedure where they officially abandon the property. As soon as they do that, they say, look, we don't want anything to do with that property. That puts it back into the power of the homeowner. That homeowner now can sell the property, do everything under the terms of the property.
Yep. But if they do that, we have to account for all of the lien holders. So there's this myth, and I think it comes from just the way that most consumers or people going through bankruptcy view bankruptcy is it's a nuclear button, it's a hard reset, and if I went through bankruptcy, I can do whatever I want with my property after that, right?
Right, because what happens is the bankruptcy discharges the debt, how much I owe. It doesn't change the fact that these lenders and other parties have a security interest, the mortgage, against the property.
Right.
The bankruptcy does not discharge the mortgage against the property.
That's one of the most common frustrations we see as homeowners they went through bankruptcy, they're selling their property post-bankruptcy, and they say, well, what do you mean I have to pay the lender all the amount that's on the mortgage plus the back interest and all that? And to your point, bankruptcy does not dissolve liens.
Exactly.
It simply doesn't.
Right.